morning, ladies and gentlemen. Welcome back. All right. As you recall, yesterday the state rested its evidence, and I now ask of the defense, Mr. Bradsher, will there be evidence for the defense?
Based on the evidence presented by the state, the defense rests.
So, ladies and gentlemen, this concludes the evidence portion of this trial. There are still two important stages to go in this trial. That is the closing arguments of the parties and my instructions to you on the law. At that point, you'll be asked to deliberate this case. I'm going to need some time to prepare the instructions that I'll be giving to you and to confer with counsel and Mr. Bradsher about those instructions. That's going to take me a bit of time to do. But once I complete that, we'll move into the closing arguments and then the instructions. Unfortunately, I'm going to need to take that time. It'll take us several hours to prepare those instructions and have that conversation I need to have. So I'm going to recess the matter for your benefit this morning and ask you to return at 2 o'clock. At that point, we should be in a position where we are ready for the closing arguments in this case. So as you can see, things have moved rather more quickly than I even anticipated for you yesterday. And so therefore, you should be in a position where you're deliberating this matter perhaps late this afternoon or certainly by tomorrow. So that's the status of the matter now. But I apologize for this gap in time for the next several hours, but we need that time to confer so that we have the instructions on the law in the correct form to deliver to you. So with that being said, we'll excuse you until 2 o'clock. We'll ask you to gather in the deliberation room at that time. Please follow all the rules and instructions. Don't talk about the case among yourselves or with anyone else. Don't form or express opinions about the outcome. No media or independent investigation into these matters, and no conversations with parties, witnesses, or lawyers. Thank you again, and we'll see you back at 2 o'clock. All right, outside the presence of the jury, at the close of all evidence, are there any matters that we need to take up?
Yes, Your Honor, I would renew all motions I made at the end of the state's evidence. I'd just like to be heard additionally on just a few minor points.
Yes, sir.
With regards to the obtaining property by false pretense, now that all the evidence is in, I was able to confirm through a transcript last night that state's evidence through Ms. Tant did present, and it is uncontradicted before the jury, that all the way back to 1980, employees received their paycheck regardless of whether they had entered their time worked or their leave taken. So I contend that it's undisputed evidence before the jury that even not entering time in Beacon, there's still a payment will be made. So to the extent the state relies on Beacon entries as part of their case in chief, I would contend that the obtaining property by false pretenses should be dismissed. I do concede that within those three claims that there has been testimony that approval of time would confer some benefits such as leave time, but the way it is alleged with regards to the defendant's exposure to salary, I would contend that that should be dismissed at this point. I also asked the court to revisit indictment number 6. I also researched this last night. I contend to the court it is very clear that as charged, there has to be impeding, delaying, and obstructing the investigation in legal and public justice. And I would contend now that all the evidence is in that indictment should be dismissed. In the alternative, I would contend that at the very least it should be reduced to a misdemeanor. The state has used common law misdemeanor obstruction language in indictments 5, 6, and 7 and attempted to make them felonies by alleging this in secrecy and malice. I would contend now at the end of all evidence, there is not sufficient evidence to show secrecy and malice, and therefore as to 5, 6, and 7, I would also ask the court to either dismiss and or reduce these to misdemeanor charges. And just so I'm thorough, renewed all motions I made at the close of state's evidence. That's the only additional arguments I wanted to make.
All right, thank you. And the motions are denied. I'm going to need about 45 minutes to complete the instructions, so we will be in recess until 10:30, and then we'll gather. I should have copies for you at that time, and we can hold a charge conference. All right.
Of course, I do recess at 10:30.
All right, welcome back, ladies and gentlemen. I apologize for taking a bit longer than I anticipated, but I think we now have at least a set of instructions that I would submit are ones that I would propose to give. I'm still waiting for my computer to boot up so we can go over them in more detail. All right, so just for the record, the instructions that I would propose to give would be 101.05, function of the jury, 101.10 is burden of proof and reasonable doubt, 101.15 is credibility of witnesses, 101.20 is weight of the evidence, 104.05 is circumstantial evidence, 104.25 is accomplice testimony for the prosecution. 105.20 is impeachment or corroboration by prior statement. 101.30 is effective defendant's decision not to testify. Then on the substantive offenses, we start first with felonious conspiracy. And I've included after each of counts 1 through 6, the aggravating factor that was alleged by the state that the jury would be asked to consider with those 6 counts, and that aggravating factor being the question of whether the defendant held public office at the time of the offense and the offense related to the conduct of the office. Then with count 2, so the felonious conspiracy count, just for the record, is 202.80. That's the pattern instruction. For count 2, it's obtaining property by false pretenses. That is pattern instruction 219.10. And again, the aggravating factor follows that. Count 3 is aiding and abetting false pretenses. That's 202.20. The aggravating factor follows that one. Count 4, 5, and 6 are each obstruction of justice. That is 230.62. I've included the third element that would elevate it to a felony, that the defendant acted with deceit and intent to defraud. So that's included in each of those 3 counts. And the aggravating factor is included after each of those 3 counts. Count 7 is failure to discharge duties of office. I could not locate a patterned instruction for that, so I created one from the statute at issue, which I don't. The statute being General Statute 14-230. So there are 2 elements to the offense, and that seemed to track the statute pretty closely. Then finally, the concluding instructions are 101.35. So I know you've had a little bit of time to review these, and we can create additional time to review them before we reconvene with the jury. But let me ask by asking the state, are there any objections, additions, or corrections that you note thus far in your review of the instructions?
Excuse me, Your Honor. I think Your Honor has calculated the instruction, created the instructions in a way that is satisfactory to the state. The one thing that I would request or mention to the court is under count 1 of the felony conspiracy, and it would be the second element thereto, which is second, that the agreement was to commit obtaining property by false pretenses. The offense of obtaining false pretenses has 5 elements, and the first element that you have listed is that the defendant made a representation to another. The only request that I would have would be to include some sort of language that the defendant and or a co-conspirator made a representation to another. I think that would track with the obtaining property instruction that you give in the next count, as well as the aiding and abetting theory that you have described in count 3, I believe. I just think it's more consistent, since those the languages in each of those would say that the defendant can make the representation or any other party to the conspiracy can make the representation. So that would be the one thing that I have noted thus far.
All right, and that reminds me that in count 2, I actually added language of acting in concert, and that is taken from pattern instruction 202.10. So I note that that's an addition to count 2. I don't think that it applies to any other count.
Correct, and that was one of the instructions that I was going to request, but I saw that you added it, and so.
Right. I understand your concern. I may find another way of stating that because, of course, for a conspiracy, not all of these acts need to be done. Just simply the intent to carry it out. So I think the definition actually needs to be a generic definition. The pattern instruction just simply contemplates that the jury be made aware of what the offense is. And so that would be what I would intend to say here. I don't want to give the impression that each of these elements must be carried out in order to have the completed offense of felonious conspiracy, but rather that that the parties to a conspiracy agree to commit a certain crime, and that crime is defined by these 5 elements. But I see your concern, and I think that's a valid concern, but I may tinker with that a bit more. All right, any other objections or corrections that you note?
No, Your Honor, not at this time.
All right. Mr. Bradsher, do you have any objections, corrections, or suggestions to the instructions as you see them now?
Yes, sir. With regards, first of all, the aggravating factor, the defense would object to them being integrated with the substantive offenses. The defense contemplated there would be a bifurcated proceeding, that should the jury return verdicts on any of these matters, that then they would consider the statutory aggravating factor. That is what I'm accustomed to in terms of practice, both as a defense lawyer and a prosecutor. I think to integrate the alleged aggravating factor while they consider the substantive offense is unduly prejudicial.
Do you have any authority for that?
No, I was surprised to see it integrated this way. Again, my practice has been to submit the substantive charges to the jury, and if there was a return of guilty, then to consider aggravating factors that have been proposed by the jury, by the state. Otherwise, the consideration of the aggravating factor would be done in concert with the original determination of guilty or not guilty, and I think that would be unduly prejudicial.
And the reason I ask for authority on that is that while there's certainly some aggravating factors that the jury is not to be made aware of until after they have considered the underlying offense, those certainly are required by law to be bifurcated. My question is there authority that requires bifurcation when there is nothing inherently prejudicial in the factor that is being considered? Namely, it doesn't relate to a prior record or prior violent conduct or other things that would be inadmissible for a jury to consider. while they're considering an underlying offense
Don't have a case, no, Your Honor. I'd simply say
or
that
statute. I mean, it's,
it was just a surprise to the defense because the defense position, and I don't have a case to hand you, would be that it would be prejudicial to determining the initial issue of whether it's guilty or not guilty. It is right there with the guilt-innocence phase to then consider an aggravating factor, and it appears, I guess, 6 times or 7 times. I mean, it reinforces the state is pursuing an aggravating factor as they are determining the facts of the case and apply it to the law. The aggravating factor does have to be determined by a jury. I concede that, but I contend it would be inappropriate because that has to do with sentencing and the impact on sentencing, not on guilt or innocence.
I'll look at, of course, the instruction is clear that they only consider the aggravating factor in the event that they have determined the defendant to be guilty of the aforementioned offense. So it's certainly not conflated with the consideration of guilt or innocence. The instruction is clear that it begins with the words, if you find from the evidence, or in the event that you find the defendant guilty of the named offense, then you consider the following. So I'm going to take your issue under advisement and research it a little bit. I'm not aware, but I may be wrong. I mean, I'm not.
I may be. In terms of their existing authority, I just don't know.
Right, and I'm going to look at that as well. Just look carefully at the statute and existing authority, but I can tell you my understanding is that there's no requirement that it be a bifurcated proceeding unless it is an aggravating factor that is by its nature one that the evidence relating to it should not be considered during the guilt-innocence phase. Mr. Latour, do you have any thoughts on that issue?
I am unaware of any authority that would require it to be bifurcated. I know that that is common practice, that does occur, but I don't know. And I was trying to think back to when I've tried a DWI in Superior Court and whether those are bifurcated scenarios or not, and I don't believe that they are generally. And so I think
I've done them both ways.
Right.
And I think that there's no... I think anyway, I'm going to look at that issue. We need to get it right, whatever the law is, but
Yes,
I understand your point.
On the counts 1, 2, and 3 in the instructions, Your Honor, I noted that there was no time frame given for jury. I think given that the state has offered evidence all the way back to the initial transfer with regards to the 2 districts, the employee situation, I would ask that the time frame that's alleged be integrated into the 3 counts that the jury would consider.
Mr. Latour?
not a part of the, time is generally not a part of the pattern jury instruction, and so I would just ask that you follow the pattern, but whatever your Honor's inclination is.
All right. I'll consider that. My view on that is the same way, that it's not part of the patterned instruction. It's not an element of the offense. It's certainly so I'm not inclined to add superfluous language if that's what it is. Now, again, I'll look into the issue further and see whether it is something that...
Your Honor, I simply assert again, as I did yesterday, I think it's a procedural due process issue where a defendant is put on notice that the crime allegedly occurred between April 1st and October 24th, and then the state puts in evidence of something that goes all the way back to January 2015. The jury has no context as to when such agreement was done. So to expose the defendant to a decision outside the time frame he's put on notice for, I think it would even jeopardize the rights on double jeopardy. I mean, so again, I just ask the court to include the time frame alleged in the indictment so that the jury has context that that is the time period the defendant was put on notice that he's defending these charges.
All right. I'll take that under advisement.
The next matter, Your Honor, as I noted on the specific date allegations, in 5 and 6 felony obstructions, there are specific dates as alleged in the indictment. However, to count 4, that date seems to be omitted. So I'm requesting that you include the August 12th date that was alleged in the indictment on count 4.
Mr. Latour.
My review of your pattern instructions only indicates that it's listed in one of the 3. I don't see it. I could be missing it in count 6.
I don't think I put it in count 6 because, again, I thought it was superfluous. I felt for the 5th count that because there were several conversations
Correct.
with David Whitley that were testified to that it was important to narrow it to a specific conversation. That's why it needed to be included on that count, but the other ones again were, I mean, count 4 is on or about, so it has some, it's not precise in that sense. The termination date of Deborah Holbrook, I didn't see.
And I would argue to say against that issue of including it the 12th, as you indicated, it's on or about, and the only testimony about any conversation between them, the only evidence that's before the jury would be not specifically August the 12th. So he's on notice as is required, I would submit, pursuant to the statute, but the jury, that's not as important for the jury when there's only the evidence of one conversation about that issue.
Have you heard on that, Your Honor?
Yes, sir.
Well, I just need to state for the record, this relates to the procedural due process that you ruled against me on with regards to the J. Stoltz statement that I handed up. The fact remains, the J. Stoltz statement talks about a phone call on August 12th and then a subsequent meeting where he enters the beacon not at my direction, but at his own direction after he received information from me. That has been proffered by the state for the first time with testimony from the witness that he has made no other statement to any other person. I don't know if Mr. Latour knows if he met with Tom Ford or made any other statement to their office or not. However, what he testified to was different than what was in the statement. I asked him about the 12th and a phone call. He did not recall that. He also made a comment that he hadn't reviewed his statement, then he said he did. And then he said as to other factual issues, he didn't get an opportunity to go back and speak to Agent Whitley. All of that, Your Honor, I contend, is fair game to be arguing reasonable doubt. If the jury doesn't have context that the state alleged that this occurred on August 12th, I contend it's prejudicial to the defendant. Likewise, Your Honor, as to 6, the allegation specifically in the indictment was that the obstruction of justice occurred on January 11th, a date of the discharge. The state has put almost nothing on about that other than Gail P. did say she was present when the discharge occurred. And I asked Agent Whitley if he spoke to Ms. Holbrook the day after January 11th. So there is context in front of the jury. The jury comes in and sees no date, no context of when this act was occurred, and it's a felony act which has secrecy and malice attached to it. To make it a broad brush over a period of time, again, I contend is a prejudicial to the defendant just from a due process standpoint. So I want to make that argument as to those two dates. Thank you.
All right. Any other objections, corrections, or suggestions?
There was one more, Your Honor. I'm requesting lesser included offenses on the obstructions. Secrecy and malice, again, it argued at the close of all evidence that there's insufficient evidence for it to even go to the jury. However, that was overruled. I would contend that absent the jury finding that, the lesser included of misdemeanor obstruction should be considered.
All right, so is that only, so secrecy and malice, or let's see, there's slightly different allegations.
I believe it's in all of them. That's the language that makes it felonious.
Is it?
So I think that's
Have I included in the same?
I think you did.
Well, I've got in counts 4 and 5, deceit and intent to defraud.
I think that's part of the common law misdemeanor language, Your Honor, for obstruction. I would contend that the secrecy and malice is the element that the state has sought to elevate it to a felony.
Well, 14-3 parens B of the general statute says if a misdemeanor offense as to which no specific punishment is prescribed to be infamous, done in secrecy and malice or with deceit and intent to defraud, the offender shall, except where the offense is a conspiracy to commit misdemeanor, be guilty of a Class H felony. So as I see it, I mean, so for example, if we look at count 4 of the superseding indictment, the state alleges that on the 12th of August, on or about the 12th of August, the defendant unlawfully, willfully, feloniously, with deceit and intent to defraud, did commit the infamous offense of obstruction of justice.
I think that's correct. I think it's that would be akin to kidnapping, where you don't, or some other thing where you don't list all of the options for how you can get there. I think the element that the only elements as to misdemeanor obstruction of justice are unlawful and willfully obstructs justice. If done with deceit and intent to defraud, you get into that other language.
But then on superseding indictment 6, which is the Deborah Halbrook, there the language, rather than deceit and intent to defraud, the language is in secrecy and with malice. So that's another elevating element that moves it from a misdemeanor to a felony. As I read the statute, I mean, again, that's why we have these conferences, is to make sure that we get it right. So as I read it, the only one that has the secrecy and with malice allegation is count 6. And is that the only one that you're asking to have a lesser included offense on, or with respect to the other two, are you asking for lesser included offenses?
I am asking on all 3.
On all 3?
Yes, sir.
All right. Mr. Latour, do you wish to be heard?
Whatever Your Honor deems appropriate.
All right. I'll agree with you categorically on 6 that there should be a lesser included offense on the secrecy and with malice. That is appropriate. I thought about this issue on counts 4 and 5, and I'm not sure of what evidence would support a lesser included offense, but I will include it.
Thank you, Your Honor. The final is just for the record, Your Honor. Again, reassert that the indictment 7 does not state a legally cognizable charge, so I can't consent to the language, but I don't want to be heard further as you have crafted it.
All right, thank you. Okay, so what I'm going to do, it's a little bit before 12. I'm going to make a revision to these. I need to do a little bit of research on the bifurcation issue and the time frame issue. I'll include the lesser included offenses, so I'll make that editorial change. And then I'm also going to tinker with the language, and I think the first offense. But other than that, so I don't know whether we need to reconvene much earlier than 2 o'clock. Why don't we gather at 1:30 and have a final charge conference? Let's talk about the order of the closing arguments. Mr. Bradsher, you sought admission and without objection by the state of evidence during the state's case, and so therefore, in my view, you've waived your right to the final closing argument. So,
I agree, Your Honor.
all right, so Mr. Bradsher, you'll have the first closing argument. Mr. Latour, you'll have the final closing argument.
Yes, Your Honor.
We'll work on verdict sheets. Of course, it'll depend on how we treat the aggravating factor issue. That'll determine the verdict sheet, so we may not get to that until a bit later. Are there any other issues that we need to take up?
No, Your Honor.
And just for planning purposes, I don't know, so if we were to start at 2 o'clock as we've anticipated, I don't want to interrupt anyone's closing argument. I'd like to get both in today, but I don't. Mr. Bradsher, if you intend to run over, say, an hour and a half or so, then we may not get to, then we may be in a position where Mr. Latour would be looking at having to split his between 2 days. So.
Yes, Your Honor, that's my only strongest objection I'll ever make during the course of this whole proceeding is that I would like a little bit of time to see your final charge, and I do not want to split the arguments to where I go one day and Mr. Latour gets another. If it's going to be that, then I'm going to request tomorrow morning. I'm ready to go today. I'm not seeking a delay, but I would strongly contend, even more importantly than the law you put in the charge, is that they not be split by the overnight.
Well, I'm certainly much more reluctant to require an attorney to stop midway through an argument and recess and then pick up the next day. And you control, if we start at 2 o'clock, we have 3 hours, and you control those 3 hours. You can, if you go an hour and a half, then it's likely that we'll get to Mr. Latour. If you go 2 hours, I don't know what Mr. Latour's intentions are, and he probably can give us some forecast, perhaps, but my intention is to use this afternoon for closing arguments. So
I understand. I just want to make my position clear again.
Right. I understand your position, but I do also believe that is in your hands to some extent, as the length of the closing will determine whether Mr. Latour has a reasonable chance of completing his today, and that's why I'm letting you know that I'm reluctant to cause a person to stop in the middle of a closing, recess, and pick up the next day. I'm much more willing to stop after one party has given a closing and resume with the second party's closing the next day. That's much more commonly done.
Yes, Your Honor.
All right, thank you. All right, so we'll be in recess until 1:30 when we'll resume a charge conference, and then we anticipate having the jury back over at 2.